Coffeezilla, your slimiest. He is a lopsided journalist with an agenda, more like an internet criminal. A little gnat. It's like a little annoying gnat. The defamation lawsuit. That is happening because this is wrong. This is wrong.
Hold on.
We're going to handle this ourselves while we continue to build CryptoZoo, and I'll see you in court.
The lawsuit between Logan Paul and Coffeezilla is heating up, and honestly, this latest update raises more questions than answers. Logan Paul's legal team is fighting aggressively to keep Logan's deposition confidential and not delayed, not redacted, hidden. And when someone tries to this hard to keep sworn testimony sealed, the obvious question becomes, what happened in that deposition? Because based on the court filings in this video that we're about to react to, it does not sound like it went well. So let's take a look. This video is by Cuff Boys, who we reacted to prior to in a previous video. So we will see what the new updates are. Let's get to it.
All right, we got a few big updates. Logan's team is trying their absolute hardest to keep his deposition confidential still, because it clearly went terrible in my opinion. Coffee's lawyers did something strange in the deposition you'll see later in this video. Logan takes a few L's though, like it's pretty wild here. Hit subscribe, let's go boys. All right, here we go. Plaintiffs reply in support of motion to preserve deposition of confidentiality designation. So essentially this is Logan Paul saying he wants to keep his deposition private. Defense response to plaintiff's motion fails to justify their non-compliance with protective order. Remember they said that Coffeezilla already broke the rules with the protective order and everything, which alone ought to render defense objections to plaintiff's designation of his deposition transcript as confidential moot. Defense further failed to identify any imminent need to publicly file any portion of plaintiff's deposition transcript or to otherwise disclose it for purposes of defending the claims at issue in this action. They're trying so hard to keep this deposition private. I mean, really the only reason I can think of why they would do this is because it didn't go well. This omission...
It can also be that he doesn't want a lot of people to know what happened, and it can hurt other people he associates himself with. Another group that he's associating with himself right now is WWE, who is a group that don't like BS. They eat BS up to a certain degree because they've dealt with the whole DUI stuff from certain wrestlers, but this stuff is so big that they probably don't want to deal with it. So if it becomes any more ridiculous, WWE may not like it. But anyway, let's continue.
Underscores the concerns underlying plaintiff's confidentiality designation. The protective order entered in this case requires the defendants to meet and confer about any disagreement with any confidentiality designation before lodging an objection that required plaintiff to file a motion to preserve the designation. Coffee made no effort whatsoever to resolve this dispute before lodging their objection. Instead, counsel simply sent a one-sentence email declaring the defendants were formally objecting to designation of plaintiff's transcript as confidential. So they're saying Coffee never put effort in discussing keeping it sealed or whatever, and just sent an email saying no, objecting to that, fuck no. Defense not meaningfully dispute their non-compliance with the protective order. Instead, they strangely try to put their non-compliance on plaintiff by arguing that plaintiff filed his motion without conferring, ignoring that it was defense improper and untimely objection that required plaintiff to file his motion to preserve the designation. Defense also claimed their non-compliance should be excused because a good faith effort at meeting and conferring would not have been fruitful. But defense professed confidence about this is odd, considering that the parties have in fact been able to resolve previous disputes about confidentiality designations by conferring in good faith. So Coffee apparently said at some point, it wasn't going to be a good discussion if we got together and conferred on this, because it sounds like Coffee's going to be like, no, it needs to be public. This can't be part of the protective order, blah, blah, blah. Logan's team is saying, well, we've already discussed several things and it's been good. Like, we've figured shit out before. And some, the protective order.
So let's start with the core issue. Logan Paul filed a motion asking the court to preserve the confidentiality designation on his deposition transcript. And even in simpler terms, just like he said, he is asking the judge to make sure nobody outside the lawsuit ever sees it. His lawyers argue that Coffeezilla legal team violated the protective order by objecting to the confidentiality without properly meeting and conferring first. So according to Logan Paul's filing, Coffeezilla's lawyers didn't try to negotiate, didn't try to compromise, and didn't attempt to resolve the issue privately. Instead, they allegedly sent a one-sentence email saying the objective to the depositions being confidential. Logan's team claims that the failure alone should make Coffeezilla's objection invalid. So, let's continue.
Plainly required defense to confer in good faith before, as necessary precondition to lodging a formal objection under the protective order. Coffee failed to do so. Defense have no answer to plaintiff's well-placed concerns that defense have been utilizing discovery materials in this case for purposes other than litigating this case, and that they would do so with plaintiff's deposition transcript as well, absent a confidentiality designation. Indeed, this was a concern first raised not by Logan, but by the judge, which told the parties not to...
So now okay, the judge brought up something.
Which regard to, the judge was very concerned about the prejudicial effect of discovery materials in this case being laundered to the class action lawyers. I'm concerned with the team on the Logan Paul side that some of this information would be information that could be used in the other case, even with the protective order. So the judge was already concerned that information Coffeezilla was getting from this case was going to be transferred to people in the class action case Logan is also facing. Understanding exactly the concern.
So, okay. That's an interesting concern. So all the discovery materials from this lawsuit, if it's made public, could be shared with the CryptoZoo class action lawsuit that people are already trying to redo again. Because although it got closed a few months ago, the class action lawsuit is still trying to get a different decision. And whatever gets released in this could help them. It may not, but it could. But that is what the judge is worried about, and surprised no one in Logan's court brought it up.
It's buried a footnote in the response where they conspicuously did not deny sharing discovered materials from this case with the class action lawyers, asserting only that they have not shared any material designated confidential. Plaintiff's motion noted that at no time have defense identified any imminent need to file any portion of plaintiff's transcript for the purpose of seeking some kind of relief in this case. If the court is very concerned, quote unquote, about the prejudicial effect of defense shuttling discovery materials to the class action lawyers, and the defense have not identified any reason why they are challenging the designation of plaintiff's transcript, other than that they want to be able to engage in exactly what prejudicial conduct, then that only serves to unscore why plaintiff's designation should be preserved. This is just crazy. His lawyer is just trying so hard. I really want to know what was in this deposition, bro.
What is in it? There's something in there that could help everyone dealing with this Coffeezilla issue. And I don't understand why it could help, but because what is information that was between Coffeezilla and Logan Paul can be any different from what the other that wasn't brought up in the civil action case. Anyway.
This is gonna piss me off, man. Hold on. What does this say? It is also noteworthy that during the deposition, counsel for Coffeezilla engaged in unusual conduct such as attempting to place oversized printed posters on an easel behind Logan during the questioning. Those posters were out of the view of the witness being questioned, but in the view of the camera, again suggests that the defendant intended for some use of plaintiff's deposition video that has nothing to do with the actual litigating in this case. They're accusing Coffeezilla's lawyers of putting some sort of posters behind Logan sitting, being questioned in the deposition. Now I have to see this shit, bro. What is behind?
They put shit behind him? What? This sounds unreal. Logan's lawyers claimed that during the deposition, Coffeezilla's legal team engaged in unusual conduct, specifically saying they put these posters behind him. So it looks visible to the camera, but not visible to Logan himself. What does that mean? And let that sink in. What would that do? The witness could not see it, but the cameras could. Logan, I guess, suggests that Coffeezilla intended to use the deposition footage outside the courtroom, possibly for media or public messaging. If true, this is not a normal deposition behavior. And yes, we should all know what's in these at this point.
Him on these fucking posters, bro. What does that even mean? Oversized printed posters. Oh my God. And here's the email of Coffeezilla's team saying they're objecting to Paul's deposition being confidential. And here's the transcript from when the judge was saying he's worried about information from this case being transferred over to the class action lawyers in the other case. All right, now we got defendant's response in opposition to plaintiff's motion to preclude defendant's reliance on journalistic privilege. So remember,
So now we're talking about his Coffeezilla's journalistic privilege.
Coffeezilla hasn't released any documents because he's protected by the journalistic privilege in Texas or whatever. By law, he doesn't have to give over any of these documents. Logan's team obviously doesn't like this because they want all communications with Coffeezilla and his team and everyone on investigation. The court found that Coffee is a journalist under the Texas Free Flow Information Act. Now, months later, Paul effectively asked this court to revisit its ruling by compelling the production of over 16,000 documents, email, and audio and video files withheld for journalistic privilege. Not because the law has changed or some intervening authority compels a different result, and not because the relevant facts of the case have changed. Paul simply does not like the court's decision. So Coffee's
So it's just because he didn't like it.
team is basically saying these boys are just upset at the ruling the judge did. Take your L, fuck you. Tellingly, though, Paul did.
What? He didn't. He just. This already got ruled to Coffeezilla qualifies as a journalist under, I guess, Texas law. But now he's asking them to revisit it because he didn't like it. He just doesn't like the outcome. It's not because the circumstances changing, whether it's the law changing or something new information change. It's just he didn't like it. So he wants the court to look at it again.
Does not address
Crazy.
the decision head on and or ask the court to reconsider under the relevant legal standards. Paul instead makes up a new standard, mischaracterizing the evidence, and then applies the mischaracterized evidence to his made up standard. Paul is simply wasting the court's time, and the court should deny his baseless motion. A journalist entitled
Baseless motion. Damn.
to privilege is a person who, for a substantial portion of the person's livelihood or for substantial financial gain, reports, investigates, and or publishes news or information that is disseminated by news medium or communication service provider. Paul might not like what Coffee reports on or investigates. Online scammers like Paul, in parentheses.
Damn. All men that like Pinstein being Coffeezilla, reports on and investigating online scammers like Paul. They should have underlined that in bold italic it for a living, but that's precisely what he does. I mean, it's true. It, like we talked about in the previous video, and as they brought it up in a previous document, if he's getting attacked because of journalistic privileges, why haven't other media outlets bigger than him have been attacked with the same situation? He just doesn't like taking L's
For a living, but that's precisely what he does. Oh my gosh. Online scammers like Paul.
like Paul.
Love that. Paul notably does not dispute he meets the definition. He instead invites the court to create a new law based on principles of journalism that have nothing to do with the Texas Act. Paul only justifies his claim for the Texas Supreme Court has held courts should depart from seemingly.
So he basically not even disputing that Coffeezilla meets the legal definition of a journalist. He's just arguing that the law should be interpreted differently. It doesn't seem to be landing well
plain
for him.
meaning of a statute when the departure is warranted in light of the statute's context. But the case Paul cites says the opposite. Oh my God. So he's just trying to reinvent his own rules, it sounds like. Logan claims Coffee is biased and not real journalism. Coffee's team says Texas courts have literally held bias is not the test for journalistic privilege. This man Logan just taking L's, man.
Taking the L's, man.
Journalistic privilege. He just can't get these documents he desperately wants. Logan also argues that Coffee's conflicted because he's involved as an unpaid expert in the CryptoZoo class action. Coffee responds saying he investigated crypto before being asked to help the lawsuit. The reporting led to the retention, not the other way around. He's unpaid and lawyers don't control his content. So they're basically saying, fuck you, we are a journalist under the Texas Act. Now we got Coffee's response to Logan's team trying to get his communications with his editor and shit. So Coffee obviously doesn't want to give over this information. Paul put forth zero new evidence. The court would only entertain reconsideration of Paul's motion to compel if he could provide new information for the court to consider. Recent motion fails to identify any new information for the court to reconsider. Paul contradicts his prior definition of the evidence he seeks to justify his second bite. Paul claims it was narrow and focused on only direct evidence, and that he is now entitled to Coffeezilla's editorial communications as circumstantial evidence of actual malice, but this argument directly contradicts Paul's prior motion
So now we're trying to find an actual malice problem.
to compel. Paul sought the exact same category of documents the third-party review would later cover, communications with sources as well as documents, notes, drafts, or outtakes in defense possession that reflect upon defense understanding as to Paul's good faith or lack of bad faith. To resolve the motion, the parties agreed to employ the third-party review team. The parties submitted a joint memorandum to third-party review team with instruction regarding the scope of review and included in their motion. So remember, they hired this third-party team.
So Logan, in order for Logan to get this whole thing of bad malice or actual malice, he must prove that Coffeezilla knowingly published false information with intent to harm. Now, here's the problem when it comes to that. Coffeezilla has already produced over thousands of pages of documents to Logan's legal team, and now they have a third-party review team. Looks like is being hired to look over the evidence of malice. So let's see how it resulted.
And now, essentially, Logan's unhappy with something that they missed. Now that the review is concluded, Paul fundamentally altered his story. In this motion, he claims the review was never intended to identify and did not attempt to identify communications among the editorial team that constitute circumstantial evidence of malice. Instead, Paul claims that the review was expressly limited to attempting to identify direct evidence of actual malice. So they're saying it went from circumstantial to direct evidence. This is disingenuous and simply not true. The third-party review team specifically searched for malice evidence, which Paul identified as circumstantial evidence, and Coffee editorial communications were included in that search. He's merely relabeling his argument in his attempt to manufacture a reason to revisit his motion. This reason alone, the court should deny. The third-party review was an agreement to resolve an issue, not a strategy for piecemeal litigation. As Paul now suggests, his intent was not to resolve the motion, but to narrow the issues for a more specific attack on Coffee's privileged materials.
So it's obvious that the third-party review didn't find anything, and now Logan's lawyers were trying to reframe the request, claiming they only search for direct evidence of malice and not circumstantial evidence. What? Anyway.
Coffee would never have agreed to this compromise. The point of the review was to provide a definitive answer regarding the existence of any malice evidence within the privileged corpus. To allow Paul to revive these requests now would render the prior compromise and the judicial resources spared but the same meaningless. Paul is already in possession of this evidence he claims is missing.
He got all the evidence.
They're saying he already got this shit? Paul is already in possession of the evidence he claims to lack. For example, Lucas, whoever this is, produced a call he recorded between himself and Coffee on October 20th, 2022, where Coffee states part of it, I think they in their heads want to have good faith intentions, but they take on so many projects and so many different ideas, and I think they end up dropping a bunch of balls and hurting people. After this call, Coffee came into possession of insider texts and...
So nothing. Logan pushed this third evidence thing, didn't get what he wants, and he's still crying.
Secret rules for selling, which had a profound impact on Coffee's reporting. The evidence which has been produced to Paul is the evidence that Paul claims he is missing, the evolution of Coffee's views upon receiving insider communications and meeting notes. Paul is not deprived of any evidence. He possesses over 50,000 pages produced by Coffee.
Yeah,
okay, I did not know.
So, again, Logan, Coffeezilla produced all these documents to Logan Paul's team and the third-party review.
That he already has 50,000 pages.
50,000.
Holy fuck. He simply dislikes the fact that neither the extensive evidence he has obtained nor the privileged material reviewed by the third party has revealed any evidence to support his theory of actual malice. So Coffee's team is just once again saying, you're just salty, the evidence isn't actually what you expected to be.
To your favor.
Malice. Because remember, that's what they have to prove in this lawsuit, that Coffee knowingly put out false information to damage Logan. A court may not compel journalists to produce or disclose any information covered by journalist privilege if the person seeking disclosure makes a clear and specific showing. All reasonable efforts to obtain the information from alternates. sources have been exhausted. I've already read this. This is all the steps they have to take, pretty much, to get everything. Paul failed to put forth any evidence to support any of these elements. Paul only argues that he is entitled to discover defense editorial communications, but fails to offer any evidence to meet his burden to overcome Coffee's journalistic privilege. The court should deny Paul's renewed motion, blah, blah, blah. So once again, it looks like Coffee's team just took a fat shit on Logan's face. Coffee's journalistic privilege.
He just took a fat crap on his face. Logan already had all the materials, he just didn't like what was shown. He tried to prove that there was malice done by Coffeezilla and ended up not being true. When you zoom out when it comes to all this, a pattern starts to form when it comes to this case. Logan Paul wants his deposition sealed. Logan Paul wants Coffeezilla's documents. Logan Paul wants journalistic privilege overturned. And each time when it came to this document, the courts and filings suggest the same thing. There is no new evidence. There's no legal necessity. There's no proof of actual malice. What there is a growing effort to control where this information ends up, because it may end up obviously in the public for everyone to see the truth behind Logan Paul and CryptoZoo and whether he actually is a scammer or not. Or maybe he isn't, or maybe his team was, or what is the truth between all that communication? Because according to Logan Paul, he says he didn't know the intentions of the CryptoZoo situation. He didn't know the people that were developing the CryptoZoo thing didn't know what they were doing or whatever, and all the mistakes they made. He's saying he was unaware of it. Maybe these documents show the truth, or maybe shows the truth that Logan Paul doesn't want to know. That information can extend to more social media outlets. It could extend to the whole civil lawsuit that is trying to be reignited by people affected by the CryptoZoo scandal. It may affect his future endeavors with other companies. It may affect his Prime thing, his Prime deals. It may affect his work at WWE. It may affect any business that he wants to do going forward with people knowing this information. How bad is it? Anyway, and when someone like this fights this hard to keep testimony hidden, like I said, the question isn't why Coffeezilla wants it public. The real question is what happened in that deposition, and who would it hurt if we saw it? So that's the update for this Coffeezilla thing. Whatever becomes public is gonna hurt him. It definitely looks that way because he doesn't want the world to see. Unless this is another big freaking stunt he was trying to do, maybe it doesn't hurt him and it's just him getting attention from people. Maybe there's another Prime drink he's trying to produce with Coffeezilla. Coffee Prime, who the hell knows? But there's definitely something in here that he doesn't want people to see, because it's going to create a chain reaction to future projects of his. It may affect his company, who knows? Anyway, that is it with the latest update with the Logan Paul versus Coffeezilla deposition about the documents being unsealed. What do you think is in these documents that may affect Logan Paul? Will it affect his career, or will he need to take another hiatus similar to his Japan tour after this information gets open to the public? Let me know in the comments, and I will see you on the next video.